the algorithmic state, market, and society, and ICON as digital constitutionalism. And this is, of course, I must say, an event and an occasion to discuss on something that is on not just in the list of our publication, but also something that is very important and related to our society, to our work, to what we do probably every day, algorithmic. So just I must give you just something, because yesterday I discovered that even the European Court of Justice has developed an artificial intelligence strategy. But notwithstanding this, but today we are here because we have, in the framework of the event, a very important schedule and very distinguished speakers, even if they are very young, I must say, very, I would say, prominent scholars. And my duty here, and Federica give me some hint if I do wrong. My duty is to chair this event, and we have, as we probably know from the flyer that has been circulated throughout these days, last week, 2 weeks. So we have Chiara Gallese, who is the keynote of today's event, and Chiara is Marie Sklodowska-Curie postdoctoral research fellow at the University of Turin, under the supervision of another prominent scholar in this field, Ugo Pagallo. But she's very keen on this topic. So Chiara, just to go very briefly to the point, thank you for being here, and thank you for this, I must say, this important keynote that you will deliver to us. And the floor is yours. Of course, the virtual floor is yours. Thank you again, and thank you to everybody. Then I will present the other discussant when we arrive to each point. So thank you again, of course, to Federica, to Giovanni for organizing this and for giving me this opportunity to chair this important event.
Thank you very much. I'm going to share my screen now. Please confirm if you can see it full screen.
Yes, we can. Thank you.
Okay.
Yes.
Thank you very much. So today I will briefly present my project. It's called Datacom. It's funded by the European Union, but I must disclose that the opinion are my own and do not necessarily represent the one of the European Commission. So my project started last year in July, the very first day of July, at the Department of Law of the University of Turin, and it's scheduled to last for 2 years overall. The aim of this project is to facilitate an ethical reuse of data, health data, by the public administration. I will just very briefly describe the objectives and methodology of my project, because it's relevant for my talk today. So the objectives are to understand how health data is reused by public bodies. So by public bodies, I mean all public administration entities, such as, for example, public hospitals, research institutions, city council, European agency, and such. I want to understand also what are the views of patients with regard to their reuse of the data, and if they are willing to share the data, and for what purposes. And at the end of the project, I will develop some guidelines to guide public servants to reuse the data ethically. So I will go to Spain and the Netherlands. Actually, I am in Spain right now for 3 months, and then I will almost immediately leave for the Netherlands for other 3 months to conduct field work. So I will compare the 3 countries, Italy, Spain, and the Netherlands, by interviewing public servants and citizens, patients, and to understand their views and how they handle the health data. I will also study the anonymization techniques, and I am collaborating right now with a group here in Polytechnical University of Catalonia regarding the best anonymization techniques to protect health data. And I want to understand if public entities really use these techniques at the state of the art, or what are other techniques they are using. Why this project? Because first, recently, health data has become an asset, an economic asset, and a health marketplace has been created, especially in the US, but also it's gaining traction in the EU as well. So the importance of health data, of reusing health data, has increased a lot, as we have seen during the pandemic. So to trace all the movement of people, to understand epidemiology, to estimate public expenses, and also to use this data for training AI applications. So in the EU, the legislation regarding the possibility of reusing health data is very fragmented among member states, but we all know that GDPR applies in all the EU. You know, all the economic operators and private individuals who wants to process data here in the EU or target EU patients, they must comply to GDPR. But now the scenario is changing, because during this wave of regulations within the digital strategy, we have seen a lot of new data sharing options. For example, the data altruism mechanism, the Data Act, which would facilitate the sharing of IoT health data. And last but not least, the European Health Data Space, which is a very important piece of legislation that will bring a lot of opportunities for researchers, but probably a lot of problems and issues for patients, especially when we are talking about the reuse of this great amount of data that will be shared across Europe for training AI. As I mentioned, there are a wide array of ways that make the public administration reuse patient data. And all these ways can be beneficial to society and to patients, but also sometimes not very much, because health data is reused for good reasons like epidemiology or curing diseases, but it's also used to evaluate the performance of hospitals, so also to allocate funding, and to create health policy, so to make decision planning, how, for example, what diseases to reimburse under the National Healthcare Service, and to make all these decisions that could be detrimental. But it's also used for AI training, which means giving a huge amount of patient data to an automatic systems that can assist doctors, or sometimes that can assist epidemiologists and policymakers to make decisions about patients. So there are a lot of risks associated to all this framework that we have seen, especially when we talk about feeding health data to AI systems. We know that AI systems can be very, very important, especially in cancer research or diagnostic. So it's a good thing that we use AI. We can improve science, we can improve diagnosis, but there are also many risks, especially related to discrimination. And we will see in the following why. Health data using with the AI, if the AI is not properly trained, can also cause some problem like cutting funding or or preventing the access to technology to people that are not so skilled with technology, because now we have seen a lot of medical devices in IoT. So, for example, in wearable technology, so some people have access to this AI technology, some people don't, because they are not skilled with technology. We can see also cases of malpractice because the AI can be wrong, and humans tend to incur in automation bias, so to trust technology. And of course, there's the never-ending problem of data breaches. So it's good, AI is good, but there are also some point of attentions that we need to consider. So firstly, we need to take in mind that healthcare itself is a venue, an endeavor where there are a lot of biases. So there is a racial bias, gender bias, socioeconomic bias, ableism, as we have seen during the allocation of ICU beds during the pandemic. There were some claims that the person allocating resources were considering cutting ICU beds for people with certain disabilities, especially mental disabilities, and so on. So healthcare just in itself is a very particular field. If we add AI, then we have even more problems, because it's known that within AI training, there are a lot of bias problems. So firstly, the data sets used to train this AI are not representative of the population, but are heavily disproportionate toward the US and Chinese datasets. And the people doing research also, usually it's white males and from high-income countries. So this is a source of bias in itself, in the AI creation itself. There is also human bias, because in supervised models, the data that is fed into the system is labeled by certain doctors, certain experts. And who selects these experts is also a problem. They usually are white males, which have a certain affinity to the person building the model. And this lack of representation is a problem in the model itself, because the model is less accurate in all its outcomes. So this is a figure from my ERC proposal, where I depict how biases are embedded in all the AI life cycle in healthcare and in within the the first phases of its creation, so since the data collection. We see that the health data, especially clinical health data, are collected by doctors, which are biased in itself, as we have seen. They examine the patient and note the clinical data, fill in paper or electronic records, and put it in a system. And in this phase, a lot of biases might occur. Subsequently, there is the dataset preparation phase where the data is extracted, pre-processed, and structured to be fed into the AI model. And this is a phase that I'm researching about, which is very delicate, and many biases, especially statistical biases, may occur. And then there is the AI creation itself, where there is a computer scientist, who hopefully, at least sometimes some people trained in biology or in medicine, that create a model, choose what model to use according to the purposes. They use health data to train the model, they test it, they decide how to test it, they then adjust the model, and in the end, they deploy it. So also in this phase, a lot of things might go wrong. Well, what are the problem of this process, especially in the training phase? So the data, in order for the model to be accurate and to function properly, the data must be representative of the reality. So if the reality is biased, if there is a bias in healthcare, also the data will be biased, and the model in the end will be biased and create discrimination. In our recent paper, we identified 6 features of a health data set, and we explained what could be a problem in preparing the data and using the data to train AI. For example, how many data do you have, and from which patients? Because normally you need to have as many examples as possible, but at least 10 times the number of features that you are selecting in your model. The data must be also balanced. So all the relevant classes must be represented, otherwise the model will have prejudicial effects on individuals or category of individuals, because the model won't be able to generalize. There are also other problems, such as the fact that the data might have some outliers or inliers. So, for example, some values could be wrong because the data collection was performed wrongly, or the data might be incomplete, and you cannot use machine learning with incomplete data because the model would just break. There is also the problem of quality. So the quality of data is very important, otherwise the model would just learn the noise or the wrong, for example, in the case of images, a wrong image. And also, of course, there are a problem related to ethics and law. So is it possible to use that data set to train the model or not? Is it ethical to do so? Is it good for that specific purpose? And so forth and so on. So there are some corrective measures to overcome all of these problems, but it's not very easy, and especially it's not common knowledge in the healthcare field and in the computer science field. We are trying to do research in this, so to understand, for example, what organizational measure we could implement within the organizations to train all the stakeholders, to make them aware of the problems, evaluate the biases, and implement all the ethical and legal principles. There are technical measures also, but they are very, very difficult to apply. And most of them, they will also introduce some degree of bias. One important element is the inclusion of domain expert in all the AI life cycle, because if only a computer scientist would create the model without any knowledge of the problem that they are trying to solve, then the model most likely will be biased. And then there is the human oversight, which is now a measure required by the AI Act, and all the assessment of risks and other problems that might arise in the use of AI and in the building of the AI. And of course, what is needed most is a continuous evaluation of the AI life cycle. So, for example, pre-evaluation, pre-processing evaluation of the possible risks of the creation of the AI. What are the stakeholders involved in the process? To whom this system might impact, and after the system is deployed, to evaluate how it is going. The AI Act is a step forward. It's not sufficient, but at least it would have a lot of requirements and obligations that would mitigate a bit the problem of AI biases. But we see that there is a lot of work to do. We will wait for the final text, but it is known that an agreement has not been reached on all the sensible problems. So what we are doing in our research groups is to use the technique of anticipatory regulation. So conducting pilots, experiments to test the new regulations in the digital strategy with the technology makers and the stakeholders. So together, we try to implement legal and ethical principles while the cutting-edge technology is being created. So I conducted 2 pilots, one in Eindhoven, one in the UK University, and we are submitting the papers in these days. In this pilot, we use a controlled test bed, so we did not deploy the technology in the end, but we use just this proof of concept examples to develop new frameworks for the practical implementation of legal and ethical principles, in particular the Trustworthy AI Guidelines and the AI Act. And we also involve the relevant stakeholders, as I am doing right now in my Datacom project. So I thank you for your attention. And if you want to contact me, I'm very happy to discuss with you about these topics and to collaborate together if you like this type of research. So thank you very much. I hope you enjoyed the topic.
Thank you for this brilliant and very precise and presentation on the topics that you are doing within your research. So thank you again. And now we move to the round table with our discussant. The first discussant is Natalia Menendez. Natalia is PhD candidate at the UI in Florence, in Fiesole, and she's conducting research on the principle of proportionality and facial recognition. We know your topic, but Natalia, you will discuss with us a blog post. So the rules, you know, everybody know the rules, and 4-5 minutes, just a pitch, and then we have a Q&A, because this, I want just to to highlight this, because of course there are many questions also from the point of view of Chiara's presentation. So thank you, Natalia. The floor is yours.
Thank you, Eric, and also thank you, Federica, for the invitation. So the approach that I bring in my blog post is precisely that of supervision. So right now we have an AI Act, but we haven't seen it yet, let's say. So if we move back to the negotiating position of the European Parliament, they say we will have this European AI office and also national authorities. But at the moment, obviously, we don't know how that will turn out into, let's say, the reality. But the thing is, even if we have these institutions or something similar, AI regulation is kind of scattered because we have provisions that apply to AI technologies, not only in the AI Act. For instance, the most typical example is the GDPR. So what I kind of argue is that the same way that regulation is scattered, probably enforcement of these regulations these regulations and regulations applicable to AI will be also scattered. So mostly my blog post claims that at the moment, data protection authorities are acting as the main AI supervisors, in the sense that we do not have at this moment much case law on AI systems, so we cannot apply this role to courts, but we do have many opinions, decisions by many data protection authorities throughout Europe on AI systems. But my second point would be, okay, but what is the legitimacy of data protection authorities to really be AI technology supervisors from a legal point of view? And if we go to Article 1, Paragraph 2 of the GDPR, it says this regulation protects fundamental rights and freedoms of natural persons, and in particular, the right to the protection of data. So obviously, data protection authorities, the name it's clear, are there to enforce and to ensure correct application of the rights to data protection, but also fundamental rights in general. So I would say that in practice, even if we still need to wait for the AI Act, but in general, regardless of what the AI Act last position is, in practice, data protection authorities are and will be dealing with the supervision of AI. But my question, and what I would like to also bring to the roundtable and discuss with the other participants and with the public, is to what extent this scattered landscape will affect, first, enforcement, because of the questions that I already explained, but also second, homogenization. And what I mean by this is that if we have, let's say, the Spanish AI authority, we have the Italian Garante, Data Protection Authority, we have, I don't know, the Polish Algorithmic Transparency Authority, all of them deciding or saying opinions or decisions or whatever. For example, sorry to be so monothematic, but speaking about a facial recognition technology system, the risk that these decisions are slightly different or they go in different ways is not that remote, let's say. So what I would like to discuss with you, and what I do very briefly in my post, and I will conclude with this, is basically to what extent this AI scattered regulation and supervision will be affected, and if we really could have real homogeneous enforcement throughout the European Union.
Thank you, Natalia. It's a very cutting-edge problem, also because it's probably the aim of the AI Act to make everything homogeneous, but not creating an homogeneous field. But thank you. Now is the moment for Paolo Levantino. Paolo is a PhD student at Sant'Anna in International Fundamental Rights, human rights, I must say. Paolo also will discuss his blog post. Paolo, the floor is yours.
Thank you, everyone, once again for the invitation and for this platform to discuss together such interesting topics. So in my blog post, I've tried to analyze and address certain dynamics concerning what I call transboundary violations of fundamental rights. mostly related to the protection of the right to data protection. Thus concerning violations, of course, originating in third countries and affecting the rights of individuals located within the EU territory. So the baseline of my argument is that I think, unfortunately, we are too used to frame the right to the protection of personal data through the schemes of the GDPR, thus somehow forgetting the fact that the right to the protection of personal data is, of course, operationalized in its European understanding through the GDPR, but still it is a standalone fundamental right as enshrined in the Charter of Fundamental Rights and as emerging from the interpretations of conventions such as the European Convention or the ICCPR when it comes to the right to privacy. So by adopting this perspective, I think we can try to discuss on some of the shortcomings of EU regulations with extraterritorial effect when it comes to transboundary violation of EU fundamental rights. And this is because while the GDPR addresses the conducts of private companies, if we adopt an international human rights law perspective, we shift the focus on the home states where the violations originate. In this way, we could somehow try and see what happens when a given state is the one who actually has and could exercise jurisdiction to prescribe, to adjudicate, and enforce, instead of having the EU unilaterally imposing certain standards on third countries. And this is because, like, really oversimplifying, in public international law, we have some principles which are somehow summarized in Rule 4 of the Tallinn Manual on the international law applicable to cyber operations, which basically put on states some positive and due diligence obligations, implying that states are expected not to have their territory or infrastructures under their control to be used in a way that infringes on the rights of other states or otherwise generates adverse consequences on them. Of course, this perspective has some limits, because due diligence obligations are obligations of means and not of result. And also one could question to what extent third states will be expected to impose on companies established on their territory to comply with legislation adopted by third states or entities such as the EU, where this goes at the detriment of certain interests of that state. For instance, when it comes to putting in place monitoring or other mechanisms to ensure compliance on their companies. So I'm curious to know your thoughts on this topic, particularly when it comes to the relevance of not losing sight of the fact that the right to the protection of personal data is a fundamental right, which has not to be totally conflated with GDPR provision and standards. Thank you.
Thank you, Paolo, also for even to you for respecting so precisely the timing of your speech. So now is the moment of Calliope Tarsidou. She works at University of Luxembourg, and her blog post for me is very interesting also. Okay, so Calliope, the floor is yours. I hope you will do as your colleague, respecting the time, and thank you for presenting.
Thank you so much. I hope it's okay that I just prepared a very small presentation. Thank you for having me here, and I would like to present my blog post on generative AI for the legal profession. So the point of the blog post is to highlight the use of ChatGPT. More generally, I won't present the technology, but also of some AI systems such as Harvey and Henchman that are also using large language models to assist lawyers in tasks such as contract analysis or drafting, or even, as we see here, litigation and regulatory compliance. There are reported uses of these programs, such as by Ellen Dover in Luxembourg for Harvey, but also unofficially for ChatGPT. A lot of lawyers are unreportedly using it for tasks, also for translation. So the point of my blog post is to highlight the regulatory implications of these tools, and I'm pointing to three issues. First of all, regulation of the artificial intelligence technology as such, and so we have the proposal for an AI Act. We have the general purpose AI systems that are described in the draft as being having generally applicable functions, and they can be used in a plurality of contexts, and these systems are characterized as high risk. That means that we have certain steps to follow, such as data governance or risk assessment steps and the measures. And this is, of course, something that is not yet come to force, but it highlights the fact that they have a high risk for fundamental rights. We also see that systems like ChatGPT are not always accurate in the information that they are giving us, and they are not context specific, and this might create issues with content moderation. Currently, ChatGPT and generative AI in general are not tackled by the Digital Services Act because they're not seen as intermediary companies. But the issue of misinformation and, of course, harmful content as such is something that needs to be regulated. And of course, personal data protection issues. We have clients and their personal data that can be inserted in generative AI tools in order, for example, to draft a contract. And this creates issues such as what is the legal basis for this processing? Is the consent? Is it the legitimate interest of the clients? Of course, repurposing, which I also heard in Kara's presentation, repurposing of personal data for training purposes and the legitimacy of this process. And different issues that I highlight in my article as well. And the topic of this gathering here is the transnational and multidisciplinary approach to artificial intelligence. And so what I'm saying from a regulatory point of view is that I do agree personally with a technologically neutral approach, because artificial intelligence is now what we are calling narrow. But of course, by narrow, there are differentiations, and we have an exponential rise and development of artificial intelligence. So we have to be as neutral as possible. But we have to tackle the data protection issue, and we have to have concrete rules on misinformation. And just to conclude, I do believe in multidisciplinarity when it comes to tackling these issues. Of course, technical measures such as human oversight, but most importantly, societal measures that come down to education and best practices when we are using these tools. So thank you for your attention, and I'm looking forward to the discussion.
Thank you, Calliope, even to you. And now is the moment of Giuseppe Mobilio. Giuseppe is assistant professor at University of Florence, and here we'll discuss, as the colleagues before did, his blog post. Thank you, Giuseppe, and the floor is yours.
Thank you, Eric, and let me thank the organizer and especially Federica for this invitation. My blog post was about facial recognition technologies and the next frontiers of interoperability. Now, you all have heard about facial recognition technology, especially after this, after the discussion on the AI Act. And here I see many colleagues that share with me the interest in the research of this kind of technology, Natalia, Federica, and Paolo, for example. And something that has been not so debated during the discussion for the AI Act was that there are several exceptions on the strict rules on facial recognition technologies and biometric identification. It is about border controls. And I would like to give some hints about it. Then the invitation for the blog post was in order something like transnational challenges posed by artificial intelligence. And my blog post was about the EU information systems. That is typically something that overcome borders between nations. I'm speaking about large-scale IT systems that are structured in a centralized database managed by EU institutions, and a capillary network that link together EU bodies and member states. And I would like to underline three aspects, problematic aspects around facial recognition and this kind of informational system. The first one is that we are living an incredible functional creep, and there is a huge problem of how we can govern this functional creep, because when I speak about information systems, I'm pointing it out with, for example, Schengen information system or Eurodac or this information system or entry-exit system. And all these systems were conceived for specific purposes and in order to collect a specific kind of data. But over time, we lived a functional creep in order for the purposes. All these systems have been more and more used for law enforcement purposes. So a different purpose they have been conceived. There have been a functional creep about the kind of data they are able to collect and share, and the amount of data they are able to collect. And third point, all these systems have been embedded with particular technologies that are facial recognition technologies. And this idea is very distant, it's very far from the original idea of these 90s when these systems were conceived. Then here we have a problem of regulatory infrastructures, because how these huge infrastructures are structured, they have an incredible regulatory strength. And here we have a problem of legitimacy, because in the last 2 years, 2 important regulations was approved about the interoperability. All these systems, all the huge systems are becoming more and more interoperable. And this has important consequences in order to protection of fundamental rights of people and the use of such kind of surveillance technologies. The third point instead is a problem of relationships between lex generalis and lex specialis, because as I said, AI Act is going to regulate the use of these biometric identification systems. But here we have an important exceptions as a lex specialis, because large IT informational system and border checks are accepted from the regulation. AI Act will apply only after several years to this technology, and this regulation will be only taken into account. So there will be strict regulation on these technologies. And here we have an important problem of overlapping between the new regulation of AI Act and the old regulation ruling these IT informational systems. And so we have a problem of protection, also here a problem of protection of fundamental rights, and of technical standards on these technologies, and on different jurisdictions who will be in charge of ruling this kind of technology and deciding how to apply these technologies. So I believe that this issue is significant in order to stress these three topics, and I would like to discuss with you more in general and specifically about these problems. Thank you.
Thank you, Giuseppe, for raising a lot of issues, also issues related to a problem, very, today's problem. So the last blog discussant is Anna Morandini. Thank you for being here. You are a PhD researcher at UI, and you doing something related, if I'm not wrong, on recalibrating platforms, AI systems, and the EU perspective, I say. So the floor is yours, Anna. Thank you for being here and for participating to this to DigiCon blog.
Thank you so much, and thank you to everyone that was involved in organizing this roundtable. So my blog post indeed focuses on how the EU regulates AI systems on large online platforms. So these systems are used for several purposes. So they're used to moderate user content on the one hand, but they're also used to target advertisement and to recommend content to users. And so they are very influential. And I assume that many of you are familiar with a lot of the concerns that have been raised on these systems, which, for example, include the problem of over-removal of speech if such systems have significant error rates. But these problems also include discriminatory targeting of certain content, such as, for example, the targeting of job advertisements by gender. And recently in the Facebook leaks, for example, there was the problem raised of societal polarization and mental health issues that might stem from strategies to maximize usage time. So in the EU, actually, the Digital Services Act might be the most influential in tackling these issues. And this is despite the fact that the DSA does not even mention AI, but it does mention algorithmic and autonomous systems. And for these systems, it forces online platforms to inform their users in their terms of service and in their transparency reports. So this is, of course, mediated transparency where platforms need to deliver information, but it will generate a lot more public information available on these systems. And very large online platforms and search engines will then also need to conduct risk analysis. And among the mitigation measures that the DSA suggests is to test and adopt their AI systems. And of course, the ultimate choice of the measure remains with platforms, but they will need to report to external instances, to auditors, and to the Commission. And these actors will also be able to ask platforms to actually explain how their AI systems work, which will create a lot more transparency and accountability, or at least opportunities for them. So then one might ask what the AI Act could additionally add to protection. And I think here it will depend on how these systems will be classified, which will, of course, depend on the final text that is adopted. But in the proposal, platforms' AI systems were not included as high-risk AIs. If this would be the case, then of course they would need to ensure quality of training and testing data, human oversight, and accuracy. So as it currently stands, the DSA is the EU's biggest chance to recalibrate AI systems in a way that protects fundamental rights and other constitutionally protected values. But of course, there are some fears that it might be too vague, too procedural when it comes to the risk analysis, especially. So this interplay between the AI Act and the Digital Services Act then also maybe goes to the point that Natalia raised on the fragmentation of the field, both in terms of regulation and also in terms of enforcement. So this is something that would be interesting to discuss later in the discussion. And to come to an end, as we're talking about transnational impacts as well, there are discussions how platforms will adhere to, for example, the DSA rules globally. This will depend on platforms' cost benefits analysis, but then other legislators, as we've heard, are already taking inspiration from the Digital Services Act. So here it's maybe important to mention that as the DSA is not yet implemented, we cannot really yet say if it really constitutes a global gold standard. So there's a lot of need for research in this field, which I would also be happy to discuss.
Thank you, Anna. Very interesting, even your blog.